Well, actually, I was not the one who decided it, and I think the pulse at the time of the members of Congress is that they are against. The sponsors would not be able to get the required 3/4 of all the members of the House.
So ang interpretasyon noon, Mr. Speaker, was dapat mag-joint session ang House at Senate at hindi na-carry yung proposal ni Congressman Barsaga na separate sessions pwede. Kasi ang majority noon ng mga members ng Congress, ang pinag-usapan noon is not whether or not Senate and the House will have a joint session, but okay na yung joint session. Ang pinagdebatehan noon, if I remember right, was whether voting separately or jointly ang House at Senate.
Well, actually, at the time, the interpretation adopted by the House is that insofar as charter change is concerned, considering that the provisions of the Constitution does not require separate voting, then voting can be made jointly. And
Tama
this
po.
was opposed by the Senate. According sa Senado, inasmuch as we are a bilateral body, kinakailangan ang voting natin ay separately. Otherwise, conjointly, sa dami ng members of the House 292, walang magagawa kahit na magno ang 24 na miyembro ng Senado. But insofar as the present resolution is concerned, we are categorical. We are very explicit that it will be voting separately.
Tama po. So at that time, sabi nga namin kanina, nag-agree naman kami ni Congressman Barsaga na hindi issue yung joint session. Nagpumayag ang Senado, pumayag ang House na joint session. Ang disagreement is it voting separately or jointly? Ang posisyon ng House, joint session tayo, pero voting jointly. Ang posisyon ng Senate, joint session tayo, pero voting separately. Yun ang doon nag-diverge ang House at Senate nung panahong yon.
Well, actually, the joint session was only the position of the House. The joint session was never the position of the Senate because from the very start, ang sabi ng Senado, separate voting tayo.
Yes.
So there was no agreement between the Senate and the House. As a matter of fact, during the last Congress, very explicit ang sinasabi ng Senado. We don't want any charter change at this time.
Yes.
Unlike at present, we have a similar resolution filed by the Senator Recto before the Senate.
Thank you for the information. I didn't know that. So House lang pala ang gusto ng joint session but voting separately, ang Senado pala is thinking otherwise. So at nakamalinaw naman yan sa speech ni Congressman Barsaga na there were two options then. One was that first, the two houses may come together in joint session for purposes of amendment. Tapos yung second option, siyempre, both houses might decide to do it the way they pass ordinary legislation like what we're doing now. No? So nabanggit naman ni Congressman Barsaga, the distinguished sponsor, that several years ago he proposed it. The second method, meaning to say itong ginagawa natin, but unfortunately it was never acted upon. No? So I am informed, he said that at least the House of Representatives is considering this method. So ang tanong ko po, why are we doing this method? This is not in the rules. This was not approved by the House. Why are we following this method? It was very clear from the distinguished sponsor's answer kanina that the position of the House is that it has to be a joint session. There was never any rule that I know of that says differently. The rules of the House from the previous Congresses have always been the same until now. And the rule of the House has always been to interpret that rule as saying that Senate and the House must have a joint session. When did we change the rules, Mr. Speaker? I don't remember of any discussion as to changing the interpretation. It seems that there is a new interpretation now being propagated in the Committee for Constitutional Amendments that says otherwise. Do we hear a majority of us agreeing to that kind of interpretation? That was the previous rule, Mr. Speaker. I do not see any change in rule and I do not see why we are here. This is unconstitutional. We are following not only a rule that is not found in the Constitution, but a rule that is not found in the House of Representatives, Mr. Speaker.
Well, Mr. Speaker, before I can intelligently answer the question of my distinguished colleague, may I know, just for the record, what rule has been changed?
The rule on...
Because he is asking, the rule has been changed. So ang tinatanong ko po, ano bang regulasyon ang ating binago para naman masagot ko po ng maayos?
Yes, Mr. Speaker. It is the rule on the proposing amendments to the Constitution. That Congress, ang sabi na pinag-agrihan naman natin kanina, ang Congress can of course, under our rules, can of course propose amendments to the Constitution. Ang nakalagay naman yan, just like you're passing an ordinary legislation, di ba? Pero ang interpretation dyan ng House has always been, it should be through a joint session. Ang disagreement lang naman talaga doon, whether voting separately or jointly eh. Pero joint session ang position ng House noon. I was here. I was here during the time of Speaker Nograles. That was the big issue. But the position of the House, and that was admitted by the distinguished sponsor, was that joint session. In fact, he mentioned in his speech, I proposed the second method, but that was never acted upon. So why are we following a rule that was not approved by the House?
The rules of the House are very explicit, Your Honor. As a matter of fact, I have repeated the rules of the House during the committee deliberations.
Yes.
Rule 20, proposals to amend the Constitution. Section 140. The Congress, upon a vote of 3/4 of all its members, may propose amendments to or revision of the Constitution. Section 141, form of proposals and procedure for adoption. Proposals to amend or revise the Constitution shall be by resolution which may be filed at any time by any member. The adoption of the resolutions proposing amendments to the revision of the Constitution shall follow the procedure for the enactment of bills. And Section 142, Constitutional Convention, the Congress, this is not applicable. Nowhere in our rules is it required that there must be a joint session. Simply because, considering that the Senate is an equal body, we cannot impose the Senate any rules. And furthermore, the Constitution under Article 17 does not require a joint session. It merely requires that Congress can convene to propose amendments or revision of the Constitution subject to the condition that such amendment or revision must be approved by 3/4 of all the members of Congress.
Thank you, Mr. Speaker. There is correct. There is no provision here for a joint
Thank
session.
you very much.
There is no provision here for a joint session. Now, there was no provision for a joint session then. Nung panahon na sinasabi ni Congressman Barzaga, the same rule. But Congress has decided that that rule means a joint session. In fact, Congressman Barzaga admitted in his sponsorship speech that he proposed the second method, that the House and the Senate separately decide the proposal without a joint session, but that his proposal was not acted upon. So this is not the rule that we are saying now. In fact, he admitted in his speech, I am informed that at least the House is considering this method. Meaning to say, the House has stuck to its rule before that there must be a joint session. What the House may be doing now is that it's considering the method proposed by Congressman Barzaga, but the House has not decided to apply that rule. So why are we here, Mr. Speaker? Why are we applying a rule that is not the rule of the House? Walang joint session nakalagay dito, pero wala namang joint session nakalagay noon. But that was the opinion and the rule of the House.
Well, it can never become a rule unless it is stated in the rules of the House. The best evidence of our rules would be the rules as printed and as approved by us on July 24.
But
and it is even possible that the rule of the House in the 15th Congress can be the subject of change.
Yes.
Kaya yung sinasabi nating rules
But there was
ng
no change,
15th
Mr.
Congress, hindi nangangahulugan, yun din ang rule natin ngayon.
But there was no change, Mr. Speaker. Same words. What the rule was during the time Speaker Nograles, the time of the 14th Congress, the 15th Congress, there was no ChaCha. Now, the same words, there were no changes. So how come there is now a change of interpretation? And did the majority of the members of this House agreed or voted to the change of interpretation? That was the interpretation of all members of the House before. The same rule read by the distinguished sponsor. But everyone here agreed that it must be by a joint session. And even the distinguished sponsor admitted that his proposal, that both houses separately decide on the proposals, was not acted upon. It is not the rule of the House. And his point was the House is considering this method. Meaning to say, it's not the rule. So all these things we are doing now is not even the rule of the House. That is what I am saying, Mr. Speaker.
Mr. Speaker, ikaklaro ko lang po. Unang-una, yung pong sinasabi niyang rule of the House na joint session, wala sa present rules of the House at wala rin sa
Before.
rule during the previous
Yes,
congresses.
you're right.
Consistent. Pangalawa, ang sinasabi niya, binabago ko ang interpretasyon ng rule of the House based on my interpretation in the previous Congress as to the present congresses. Well, it's possible that I might be changing my interpretation, but I am changing my interpretation to make the realistic approach na as long as there is 3/4 of all the members of the House approving it, that would be compliance with the law. Ang sabi ko nga, pati yung interpretation ng batas, Korte Suprema na, who has the power to interpret the laws, binabago na ang Korte Suprema, katulad ng PDAP, constitutional noong 1994, constitutional noong 1996, constitutional noong 2006, binago ng Korte Suprema ang interpretation.
But
the final issue here, Mr. Speaker, is whether or not what we are doing in accordance with the method prescribed by the Constitution for amending or revising it. Yun lamang po ang final question.
Salamat po.
Naayon ba sa saligang batas ang ating ginagawa na pagbabago ng ilang probisyon sa ating saligang batas?
But the interpretation, Mr. Speaker, of the distinguished sponsor was not approved by the House. So the new interpretation must be approved by the House muna. There is no approval of that interpretation. In fact, there was an admission that the House believed that Section 140 and 141 requires a joint session. So, I'm sure each and every one of us has our own interpretation, and the distinguished sponsor and I could have our own interpretation, but we cannot make it as a rule unless it is approved by the House. And I haven't heard of any approval or votation on the part of the House to change that interpretation. But in any case, Mr. Speaker, that is what we're following now. No? So, for me, this is really unconstitutional, but that's my opinion, Mr. Speaker. The Chief Justice of the Supreme Court also said it. The Constitution didn't say joint session. The Constitution didn't say voting separately. But every one of the constitutional commissioners, even Justice Ascuna, who was in favor of this resolution, said, well, that was our intention, pero hindi namin nalagay. Now, pag hindi siya nalagay, Mr. Speaker, hindi nilagay kung joint o separate ang session. There are two possible interpretations. As any person, not necessarily lawyer, kahit sinong tao, which one will you follow? The one that was the intention of the Constitutional Commission or something that was not the intention of the Constitutional Commission? Even Justice Ascuna admitted that the intention of the Constitutional Commission was to place there that Congress, upon a vote of 3/4 by both houses of Congress in joint session, but voting separately, may propose amendment. That was the intention. Ang sabi niya, lapse daw of old age or something, nalimutan nilang ilagay. But it's clear. So here we are, a constitutional provision that could be interpreted both ways. And as far as I know, the actual interpretation should be, pupunta ka sa intent. And the intent was very clear, admitted even by members of the Constitutional Commission who agree with ChaCha, who agree with this resolution, when they said, yun na intensyon namin, pero nalimutan namin eh. So I think it behooves Congress to follow the intent of the Constitution rather than an interpretation that was not even approved by this House. Yun po ang punto ko doon. At hindi ko makita kung bakit we interpret it in a way that was not the intention of the Constitutional Commission. I don't see any jurisprudence or any legal argumentation to support a view that we should interpret it in a way that was not intended by the framers of the Constitution, Mr. Speaker.
Am I now permitted to reply? Mr. Speaker, my dear colleague?
Yes po.
Go ahead.
Unang-una, malinaw naman po na sinasabi ng ating saligang batas under Article 17 na pwedeng baguhin ang ating saligang batas as long as there is approval of 3/4 of all the members of the House. Tama po ba yon?
Tama po. It could be
Okay.
interpreted both ways.
At hindi rin nakalagay sa saligang batas whether it would be voting jointly or separately.
Tama po. It could be
Okay.
both ways.
Ang sinasabi po ng ating kaibigang si Congressman Colmenares, through inadvertence, sapagkat ang layunin ng mga members ng Constitutional Commission, magkaroon lamang unicameral body, through inadvertence, nung matalo yung unicameral body, through inadvertence, ay hindi nailagay yung voting jointly. Tama po ba yun?
Tama, Mr. Speaker.
At sinasabi rin ng ating kaibigan na as a lawyer, wala siyang alam na jurisprudence.
Na nagsasabi na ang interpretasyon should be against the intention of the framers.
Well, mahirap po nating makita ang intensyon. In any event,
The intention
I will-
is clear, Mr. Speaker.
Okay.
It was admitted by the members of the commission.
Okay.
That the intention was to put in voting separately, joint session. That was clear. Even Justice Ascuna, who is in favor of this resolution, admitted that that was the intention.
unang-una, ito pong ating saligang batas, 1986 Constitution, was ratified by an overwhelming majority. At kasama po sa ni-ratify yung constitutional provision, 3/4 of all the members walang nakalagay na voting separately and voting jointly. Posible po na merong inadvertence. Pero nung po ako ay nag-aaral ng batas sa subject na statutory construction, natatandaan ko po yung isang prinsipyo, yung tinatawag nating casus omissus. Meaning to say, a case omitted is to be held as intentionally committed. Pag merong omission, the presumption is that it has been intentionally omitted. And I would cite or quote the ruling made by the Supreme Court in the case of Francisco Chavez versus Judicial Bar Council dealing with membership sa JBC. Nakalagay po sa saligang batas, 1 member lamang. Pero ang sabi natin, ang practice natin, 2, isa sa House at saka sa Senado. Yun po, hindi rin nabago ng members ng Constitutional Commission kasi 1 member lang nilagay nila coming from Congress based on the assumption that there will be only a unicameral body. Pero ano po ang sabi ng Supreme Court? Relying on the doctrine of casus omissus. A case omitted is to be held as intentionally omitted. The principle proceeds from a reasonable certainty that a particular person, object, or thing has been omitted from a legislative enumeration. Pursuant to this, the court cannot, under its power of interpretation, supply the omission even though the omission might have resulted from inadvertence or because the case in question was not foreseen or contemplated. The court cannot supply what it thinks the legislature would have supplied had its attention been called to the omission, as that would be judicial legislation.
Thank you.
Pag sinabi po ng Korte Suprema, kailangan dito, joint session kayo, sasabihin natin sa Korte Suprema, that is judicial legislation, and that would be a violation of the doctrine of separation of powers. At dito po sa kaso ng Judicial Bar Council, ang pinag-usapan po ay yung membership na isa lamang na manggagaling sa Kongreso. Sapagkat ang iniisip nga noon ng mga members ng Constitutional Commission, it will be a unicameral body, isa lang ang nilagay nilang membro ng Kongreso. Pero ang sabi natin, in as much as we are a bicameral body, the practice is one member from Congress, one member from the Senate. Ang sabi ng petitioner, violation niya ng Constitution. Ano depensa natin? That is not the intent. Pero sinabi ng Supreme Court, it will amount to judicial legislation. Kaya ang nangyayari sa ngayon, on the basis of this decision, isa lamang ang miyembro na nanggagaling sa Kongreso in spite of the fact that we have a bicameral body in our Congress. Kaya po may jurisprudence dito.
Yes, okay na. Mr. Speaker, yes. Well, there will always be 100 nights of debating this. The presumption over the actual statement of the intent of the Constitution. Why do we deem it intentional when the framers of the Constitution say it was unintentional? So why do we use a presumption to say that, he omitted it, so we just deem it unintentional? But they're saying it was not intentional. But in any case, Mr. Speaker, I think the problem here is if we go up to the Supreme Court, that will be an issue. The fact that this is not the rule of the House now will also be an issue. That is an interpretation of the Committee on Constitutional Amendments. Lastly lang, according to the rule itself, it will pass as if parang bill, no? Para siyang bill. May we know what is the Senate position now with regards to ChaCha, this particular ChaCha, Mr. Speaker?
The Senate position is the same as the position of the House. As a matter of fact, the resolution number 1 in the Senate is practically the same as resolution number 1 of the House. I have copies of this resolution, and I'm willing to provide a copy to my interpellator, Congressman
Colmenares.
Thank
you, Mr. Speaker. I have a copy of that resolution. In fact, I did remember the distinguished sponsor saying that the Senate also agrees with us. And the basis of the distinguished sponsor is one, not one of the senators publicly contested, stated that the course we have taken is unconstitutional. 2, Senator Recto filed a resolution similar to our resolution. And 3, the resolution is of the same wording as ours, resolved by the Senate and the House by a vote of 3/4 of all these members, voting separately and pursuant to Article 17 of the Constitution. The question, Mr. Speaker, how can we deduce from these facts that the Senate agrees with us? The fact that no senators publicly stated that the course we have taken is unconstitutional means they agree with us. Sometimes they just don't want to intervene in the affairs of the other house. Maybe they have their own opinions, but they just don't want to say you're doing something unconstitutional. Secondly, the fact that a member of the Senate filed a resolution means that the Senate agrees with us. Has the resolution been approved? The fact that the resolution has not been approved doesn't mean actually that the Senate agrees with us. Otherwise, they would have approved the resolution. And thirdly, look at the wordings of our resolution. Resolved that the Senate and the House, by a vote of 3/4 of all its members, voting separately. If we agree that this is of separate, session, hindi ito joint session, why do we even need to say voting separately? Isn't it a surplusage? Of course, we are in a separate session now. We don't need to put in voting separately because we definitely have to vote separately because we are not in a joint session. But doesn't the fact that the Senate placed there. Voting separately means that the Senate may interpret this as the Senate and the House in joint session, but voting separately. Because there is no need for the phrase voting separately if the Senate believes that this is not a joint session. So actually, Mr. Chair, Mr. Speaker, the very words of the Senate resolution, in fact, teaches us that the intention of the Senate may not be a separate session, but actually is a joint session. Otherwise, they would not have placed there voting separately because that is an unnecessary phrase in the resolution, Mr. Chair, Mr. Speaker.
Do Congressman Colmenares agree that insofar as the prayer is concerned, the prayer in the House as well as in the Senate would be the same?
I think so, Mr. Speaker.
Okay. The same. In the Senate, it is expressly provided, resolved by the Senate and the House of Representatives upon a three-fourths vote of all its members, with each House voting separately to propose amendments to Article 12, Article 14, and Article 16 of the 1987 Constitution of the Republic of the Philippines. Yan po ang wording.
Are they the same, Mr. Speaker? The Senate and the House resolution, the same? Pareho po ba sila?
Practically the same.
No differences. So it's the same resolution.
Well, it depends whether it is substantial or merely clerical differences. But insofar as substance is concerned, they are the same.
Well, Mr. Speaker, Section 3 of the Senate resolution, kanina sabi ng ating House, doon sa list, ang Filipino citizens may not lease more than 500 hectares. Tinanong ko kanina yon. Bakit natin pineg dyan? Bakit natin pineg sa 500 hectares ang Filipino? Hindi ko alam, hindi ko na malalang sagot doon. But the Senate provides unless otherwise provided by law. So ang tayo, yung foreigner lang yung tinaasan natin ng leasehold, ang Senate, both the foreigner and the Filipino, tinaasan nila. Kaya may difference po talaga ang Senate at ang House at hindi nila ginagamit yung mga ilang questions ko kanina. May difference po. Tanong ko po ganito, if this is going to be a similar, like in a bill, so may bicameral committee hearing or meeting. Ito, Mr. Speaker.
Definitely.
Yes. They will be trying to reconcile.
In order to reconcile the provisions which are not the same with the provision of the Senate as against the provision of the House.
Yes, Mr.
And that is expected as what you have happened.
Yes.
As what you have pointed out.
Napaka-powerful, Mr. Speaker, ng bicameral committee. Pero pagdating dito at na bicameral committee na, halimbawa, na-resolve na nila at na-reconcile, may poder pa ba tayo to ratify it?
Definitely.
May
Otherwise, if we will not ratify it by three-fourths votes of all the members of the House, then I'm sure that there will be issues presented before the Supreme Court that there has been no compliance with the requirement of three-fourths vote of all the members of Congress.
So, will we be allowed to interpellate if there are changes? Halimbawa, binago sila sa ating proposal at are we allowed to
Well, I think that
ask
question
questions?
would be addressed to the majority floor leader. Unfortunately, I am not a member of the rules.
Yes. Actually, yung karanasan natin sa ratification, it's just ratified by ayes and nays, no? Wala na siyang, siyempre, tapos na yan on third reading, na debate na yan. So talagang ayes and nays na lang yan.
Yes.
Approve na lang yan upon ratification. Tama, Mr. Speaker.
But a seasoned legislator like Congressman Colmenares could always stand and ask for nominal voting because we are tackling a very important provision in the Constitution.
Yes.
So hindi pwede yung nays and nays. Nays and nays. Dapat ilagay sa record sino ba ang pumapayag dito at sino ang hindi. And in the event that a motion would be presented by Congressman Colmenares, I would not only second his motion, but I will also vote in favor of his motion.
Thank you, Mr. Speaker. I'm very sure actually that you will vote in favor of that motion. Although I'm very sure, hindi na siyempre as normal na tradisyon natin dito, ratification, mag-interpellate na naman tayo. Tatanungin natin yung mga representante sa BICAM committee. Bakit kayo pumayag doon? Ano bang ibig sabihin? No, it's just a simple ratification, and I'd like to thank our distinguished colleague. I'm sure we will be outvoted, but it will be a good debate siguro, no, in doing that. So, the problem is this. The bicameral committee is a powerful committee. We saw that in the cybercrime law. They inserted so many provisions, non-existent enrolled in the bills of both houses of Congress. So, ang tanong, hindi pa ba pwede sa bicameral committee, Mr. Chair, na mapasok doon yung term extension and other political amendments? I'm sure you're going to say no. But can we really assure our people na doon sa BICAM, hindi mapapasok yon? And what is the basis of our assurance, Mr. Speaker, na hindi papasok yung term extension sa BICAM?
Unang-una, yung term extension, talagang hindi papasok rito sa BICAM because the term extension is entirely foreign. It is entirely separate and distinct sa charter change na pinag-uusapan natin ngayon, economic provision. Pangalawa, malinaw naman ang ating rules. Kinakailangan any resolution pertaining to change in the Constitution, it should be referred to the proper committee. Sa Committee on Constitutional Amendment. 3. Assuming the war scenario na pumasok yan sa BICAM. That does not mean that we do not have any remedy. That does not mean na walang magagawa ang ating kababayan. We can always go to the Supreme Court and say and ask